Hey guys, and welcome to today's video. Today we're covering a sovereign citizen I've been tracking in Thurston County. He has a jury trial coming up, so I've compiled all the hearings I have of him into one video. This way, when his next appearances happen, you'll be fully caught up. Let's get started.
Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
So
my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
That's one of the worst reasons I've ever heard for wanting to go it alone in a criminal trial, where your freedom is actually on the line. Let me give you an example. Imagine you're in law with a disease that gives you only 24 hours to live unless you make it across the country to New York. Would you refuse the services of a qualified pilot just to try flying yourself? There are times when doing things yourself is fine, like tying your shoes, getting dressed, or putting on a helmet. But there are other times when it's smart to let someone more qualified take control, like flying a plane, performing brain surgery, or representing your best interests in court.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
First, you entered into a contract with the court the moment you chose to drive under the influence on public roadways. As for your claim that this court is a ne prius and must follow Rule NII, that's just a confusing way of trying to sound smart. The court is a ne prius in the sense that it makes its own decisions, independent of appellate courts, and according to law.com. The phrase court of original jurisdiction can be used in place of ne prius. So when you said this,
it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
You might want to be careful with that argument, because if the court decides you're an object, objects don't get constitutional rights. Next voice, next voice. You cannot choose which court orders to consent to. Your agreement isn't required to follow them, including your stay in jail. Now, let's move on to his next hearing, where his entire family showed up in the courtroom.
Oh, Mr. Valentine, I'm going to hold you on 15,000 cash or bond bail on each of these independently. So you'd have to postpone to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do.
I am not pro se. I'm sui juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that?
No, it's just free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
If he were trying to intimidate you, he'd give you a basic arithmetic problem. Instead, he's trying to help because it's clear you don't know how to help yourself.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
You can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And
Can
at
we
any
change it?
time, anytime you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
Want an attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm of sound mind.
I'm not denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel and talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
You're really putting the extra special in special appearance today. And did you just say, we the people? I only asked because a second ago you said you weren't a person, yet now you're speaking for an entire group. Which is it?
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
All right, that wraps up this hearing. It was pretty straightforward, filled with the classic antics you expect, and at least he brought his whole family to watch.
Do you have any questions for me? Other than that? No, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
The people are
just
special appearance.
In other words, no one cares, and you can go back to jail. Now we move on to his next hearing, which is actually the one after that, because his immediate next hearing wasn't broadcast on YouTube. From what I can tell, it was just another judge shutting down all of his motions and preventing him from putting any of his sovereign citizen arguments on the record.
no. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
That's classic. He claims he doesn't believe in the government or that it has any jurisdiction over him, but he's completely fine with the government and taxpayers footing the bill for his own.
Folks, I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to.
I object to that. You're not allowing me.
We'll note your objection. Thank you.
Oh, so he already got all the discovery. What exactly is he complaining about now? Next voice. But there was no violation, or were you just not paying attention? The prosecutor just explained that the discovery was given to your original counsel, the one you had before deciding to represent yourself. Once they realized your original counsel hadn't passed it on, they did the ethically correct thing and got the discovery to you while you were in jail, and the judge agreed.
We need to get you unmuted.
Yes, ma'am.
All right, so there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
So you're representing yourself in a criminal matter. You're in jail. And you still don't think the court has jurisdiction over you. And now you're upset because the court isn't acknowledging your fee schedule. At this point, it's clear that common sense, not special titles, is the only language that matters here.
That's not part of the motions I have here that were filed.
There was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was,
Yeah, I objected to his denial of those motions as well because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
so what I reviewed is what was filed after the 18th. And that was October 21st. I have a request to release you and your request, I'll go back, or let me get back to your court to dismiss these charges, motion to release you. And that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On 18th, on this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. Then I'll turn right back to you. So just hang in there. So, just before I get to everything, Mr. Valentine, motion request, I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney.
And then they never gave you the discovery. Okay. All right.
Yes.
All right. All right. Get it.
That's the state's understanding as well, Your Honor.
All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward and the docket and your pleading. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
Those are actually issues that are typically addressed on appeal, especially when claims of government misconduct or ineffective counsel exist only in your own mind.
Okay, so a thumb drive that he could view those, a request form for the dash cams, what does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. all the information that we would be using at trial would be was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The states had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court found that when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, for one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. So then, Mr. Valentine, as to that discovery, you thinking you're missing something or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective in the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense. And they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed sui juris because I had my own best interest in mind. And it seems that the public defenders that were appointed to me were not assisting me effectively. And this was creating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
So we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of the discovery rules.
No, that's not how it works. To get to the point you're at today, the prosecution didn't have to prove you were guilty. All they needed to do was meet the requirements for probable cause, which means showing that a crime was committed and that you were likely the person who committed it, based on the evidence and circumstances. Probable cause has already been established, which is why you're now preparing for trial.
Well, I'm not finding there's a basis in your pleadings or what I've heard today to sanction anyone for a violation of discovery. So I'm not going to do that. And now you're also, I mean, I don't know if this was dealt with, but throughout your pleadings, you're concerned about this court, district court having jurisdiction over you. Is that still at issue, sir?
Yes, there was some service issues, as I mentioned before, which for some reason keeps getting ignored. The state served my address knowing well that I was in custody. They didn't serve me the court docket for the last hearing. And that lack of service creates a lack of jurisdiction for the court.
I disagree. Those are different issues. Go ahead, though. Maybe you've got something else there. What?
Oh, I was just going to say there's also been a number of courtroom violations taking place, which is why the last judge ended up recusing himself. But beyond counsel being ineffective in mounting any defense, they convinced me to give up constitutional rights instead of enforcing any constitutional rights. They lacked to challenge anything that the state was doing. They didn't challenge or attempt to suppress the evidence. They didn't even share the discovery information with me upon my request. And the court also was violating General Rule 43, my personal pronouns, continuing to try to say I'm pro se instead of sui juris, not changing, acknowledging my name or acknowledging my status as an American national. I also submitted a letter from the Washington State Attorney General's office where they're acknowledging my status as an American national. They're acknowledging my fee schedule, but for some reason this court hasn't been acknowledging my pronouns at all.
Huh. Who would have thought that past actions can have real consequences today?
Help me understand what you would prefer.
I would prefer to be identified as sui juris, not pro se. I prefer to be identified as Michael Valentine, grammatically correct, not in all capitalizations. I am not a legal entity. I am not a corporation. I am not a trust. I am a living man, not a male. Living man. And that's how I want to be identified, ma'am.
So if I say Mr. Valentine, that's not what you want.
I would like to be preferred as American National Valentine.
So the jurisdiction, whether Thurston County District Court has jurisdiction over you at this stage, what it is an allegation of criminal behavior alleged to have been occurred here in Thurston County, State Route 510 here in Thurston County. And so and it's driving under the influence. It's a gross misdemeanor. So the district court does have jurisdiction over those things and over you, whether you agree with the court or not. I find that today. And then discovery sounds like it's been provided. We're 3 weeks out from trial.
We're 3 weeks out. The trial was like next week.
Well, next week, the 8th is the day, it's called confirmation. It's when everyone determines if they're ready for trial or if we should have trial on the 18th and 19th. So the 18th and 19th is trial. So we're 3 weeks out. So I'm finding that thus far that discovery has been provided by the state to you.
But it wasn't in a timely manner. It wasn't by the omnious hearing, which is the prosecutor's obligation.
Well, and it was provided to previous counsel who was with Thurston County Public Defense. There isn't any counsel here today now because fairly you've decided to go sui generis, as you say.
And that's why my motion for discovery asked for an investigator, because someone needs to investigate all these rules being broken by counsel, prosecutors, and various government individuals.
All right. Well, I'm not finding those rules being broken. It's kind of a broad and encompassing idea. I'm trying to narrow this in. See, discovery has been had.
To share the discovery with me and to contact me and to help build the case. If I'm requesting a discovery, wouldn't either the prosecutor or counsel have an obligation to provide that discovery?
Mm-hmm. And I see that they have now, the prosecutor has. Now as to...
But they didn't previously, is my point.
Right, and they have now. And I don't find at this stage a reason to sanction anybody or to term anybody for that. There's 3 weeks out to trial. It's sufficient time. So, I also have a motion for release. That was also, let's see, and a motion to dismiss.
And the motion to release and dismiss were both heard on the 18th. And I can provide some underlying facts.
Mr. Valentine, there's something on the 18th, but then you refiled information that I reviewed on the 21st, also asking the court to consider release and a motion to dismiss the action against you. And is there something different than what you argued on the 18th that you filed on the 21st?
I didn't get to argue anything on the 18th. The judge read and made his own decision. I didn't argue anything. He told me on the record that I would get a chance today to argue my motions, and I presented certified mail receipts of the time that those were filed to the court as an exhibit, and he didn't allow me to speak or acknowledge any of those notices or motions, which is denying me access to court and obstructing my right to be heard, which is a constitutional right, a violation of due process.
All right. And I think I understand that what you said there in your pleadings here. Now I understand that maybe that didn't come back before the court then. So here we are. So first things first, let me get back to, I have a few things up here electronically. That's why I'm looking back and forth to screens. And so the basis for the motion to dismiss is
deprivation of my constitutional rights under the color of law, governmental misconduct, and ineffective counsel.
That's going to be a no. The judge has already noted your history of failing to appear, and you even picked up a second DUI while on trial for your first. On top of that, you've openly said you don't believe this court has jurisdiction. So why are you even asking? Just walk out on your own if that's what you really think.
and then that kind of follows thereafter. If the court were to grant that, then a release from custody, or is there something else on your motion for release?
No release of is there something else besides could you rephrase that? I'm not sure what you're asking.
Sure. Well, it makes sense that if the court were to grant your motion, to dismiss, then you would have to be released. Is that what you mean, or is there something in addition? If the court were to grant the dismissal.
If they didn't dismiss me, I wanted to adjust the release conditions so that I would have a better chance at defending myself if I were released from custody. I feel like the state took extreme measures in making sure I show up to court, and I would ask, if dismissal is not granted, that we adjust that to some less restrictive measures so that I can go home, have access to the internet, to paper, to private phone calls. I would be betterly suited to defend myself if I weren't confined.
I got it. Okay. All right. Well, let me turn to the state on the issues of the request for dismissal and well, one thing at a time. There are two different motions, and then the release conditions.
Your Honor, the state would strongly object to the court dismissing this matter. We're nearly 3 weeks away from trial. There's ample evidence to support that, to move forward with this. Additionally, an ineffective assistance of counsel claim is a matter for appeal. And so for Mr. Valentine to provide to even file that, we would have to wait for the criminal trial to come to an end. Additionally, on the hearing on October 18th, Judge Buckley provided Mr. Valentine with resources. I remember watching the Zoom recording, and that Judge Buckley informed Mr. Valentine that he would be provided with legal resources that would help aid him in mounting a defense against the state. So the state would wholeheartedly object to the motion to dismiss. Regarding the conditions of release, we also talked about Mr. Valentine brought this motion, the same motion, on the 18th, where the court denied that motion as well. Part of the facts underlying that is, during that time, the state did move to dismiss one of the DUIs at that time. And so based on that, the court still found that there was a real concern for public safety. And so the court still kept the bail imposed. Additionally, from the 18th to today, according to CRR LJ 3.2, the court can only modify conditions if there's a change of circumstances, new information, or a showing of good cause. And there's been nothing within the last 10 days that has shown that has been provided or mentioned that would fall under one of those, except one of those reasons. Additionally, the state's, I've received information earlier today that the state has received the talks report from the DUI that we dismissed a week on the 18th.
Well, let's stay on this case
Okay.
alone.
And so
nothing
the
else.
state would have some real concerns on whether
Let's just stick to this case and not bring in any other facts from any other
Okay.
case.
So based on that, there's been no change in circumstances, new information or showing since the last hearing we had on October 18th. The state would object to reconsidering conditions of release. Additionally, the motion, no, never mind, Your Honor. We would just object to the motions being, reconsideration of the motions, reconsideration of the conditions of release.
Mr. Valentine, anything else?
Yes, ma'am. I would like to say, first of all, that the prosecutor shouldn't have held me or pressed those charges in the first place if they didn't have sufficient evidence for a conviction that created a prejudice status in my case.
All right, now we move on to our final video of the day. It looks like Valentine managed to scrape together enough money to bail himself out of jail, which probably means he can also afford his own private investigator.
And many other individuals who were booked who...
Are you also talking about a case that's not this case, or is it this matter you're talking about?
I'm referring to how the prosecutor had other charges pending, which was a condition.
I'm not going to consider any other charges, either side. Let's focus in on this one and this one alone.
Okay, so for these charges, I would be challenging the evidence that the state has. I don't believe they have probable cause. The trooper is claiming that I almost struck him. I did not almost strike him. And it's clear that there's discrepancies between his report and the video footage that I observed. I am not a danger or threat to public safety. I caused no harm. I cooperated with police. I pulled over when I was asked. I've been operating in good faith and have come to court and tried to resolve this to my best effort. I did a DUI impact panel. I was on an ankle monitor, and I've been in here for multiple months now. I think I've shown that I am operating in good faith, that I am trying to get this resolved as soon as possible, and I would ask that you consider that. And if I may add, Your Honor, I was never cited for any traffic violation. The state trooper made an assumption claiming I almost hit him. His back is to the camera as I'm passing the vehicle. I did my due diligence and gave him room because they're standing right on the shoulder line of the side of the road. I moved over and gave them plenty of room and went around them. And that's clear in the video that I was never close to striking his vehicle or the pedestrians on the side of the road.
So disputes as to evidence, I mean, that's why we have trial scheduled. You'll have an opportunity to cross-examine all witnesses that are brought by the state. And of course, any witnesses will be available to both sides so that American National Valentine has the opportunity to question them. So who's on your witness list stays on your witness list. I found that discovery has been provided. I'm not finding it's untimely given the 3 weeks we have till trial. As to release conditions, the unfortunate part is I'm not going to change those conditions of release. They've been reduced to 5,000 cash or bond, and that you stay clean and sober and law abiding. And but given the amount of time we've had to issue warrants to get you back before the court, that's really a big part of why you have to postpone to get back in, and also because DUIs do pose a danger to the community. So denying your motion to dismiss, there's nothing before the court here. I think you're going to have this opportunity to question and present evidence at trial, and that's what that's for. That's not a basis. The disagreement in evidence is not a basis to dismiss at this juncture, and you will not be released on different conditions. The conditions stay the same.
Yeah, my motion to dismiss was based on the misconduct. It wasn't based on the evidence.
Well, I read several motions here, so thank you. I saw it also as to what you've said today about evidence or the lacking thereof. Misconduct, I haven't found any, I don't have enough evidence here to show that anyone was acting wrongly. If there is an ineffective assistance of counsel from before you chose to go representing yourself, then you would have to show how it applies if you're convicted, how it applied to that conviction, and if there was in fact ineffective assistance of counsel, but you're representing yourself. So that's, and it doesn't make a whole lot of sense right now.
I'm not doing that because counsel was ineffective, and the last judge denied me access to court and obstructed my constitutional right to speak. Isn't that grounds of misconduct, ma'am?
I don't find, I don't have enough evidence to find that. So
There's
that's the issue.
I have witness statements that were submitted to the court. My family showed up at court and witnessed the judge not let me speak, not let me present my judicial notices or motions. And it's also recorded that he did such.
So I know you disagree with the court's decision.
To the fact it was misconduct?
I don't find misconduct. I don't have enough evidence to find that. And so we're set for trial confirmation November 8th. I'm going to keep everything set as is. Trial is scheduled for November 18 and 19. And if you postpone, then you bring yourself in. If you don't, then we'll be sure that you're there. The facility will be sure that you're there.
I'm indigent, ma'am. I cannot afford a $5,000 bail. Is there any way we can bring that down anymore?
Of course you don't understand the legal jargon, and you probably don't get the rules of procedure either, because you didn't go to law school. That's exactly why the Constitution guarantees the right to legal counsel, so everyone has access to someone who actually knows the law and can properly represent them.
And again, I'm not going to change that bail amount. We've reduced it already earlier, and I don't see a substantial change in circumstance is what Rule 3.2 requires of me. So everything stays the same. All right, so
Well,
covered everything. Yep.
To a higher court.
You can always go to the Superior Court and ask for a writ to overturn any of the district court's decisions. But right now, we're still proceeding to trial until which time the higher court tells this court to stop or to do something else.
Yes, I am.
So that's it for this afternoon. I'm just going to send you down notice again of all the court dates so you have them. And then we're back November 8th is our next court date. And you have that in hand. Right. I think that's it for the afternoon. Thanks, Mr. Thanks.
I had one more question.
Yep.
So I still have to have a scram bracelet and can be released on my first DUI. Isn't that for people who have previous convictions of DUIs?
It can be. It can also be because of a history of use and a nexus to that.
Where is that history of use?
Well, we've got things, let's see, going through a history of crimes committed either under the influence or minor in possession or controlled substance possession alleged in Olympia. Well, that allegation was going on, and then this allegation. So all of that.
How long ago was that?
And then as a juvenile, there were several events as well. So there's a nexus to the criminal history that the court knows of, as well as the event itself. So the conditions remain the same. And we'll be back November 8th. That's all for today.
All right, now that you're all caught up, we'll wrap it up here for today. It looks like his upcoming hearings are going to be lengthy. So I'll cover those individually as they happen, and hopefully we'll see a conclusion.
Okay, so Mr. Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial. So we'll do that. Otherwise, all the rest we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance of counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is, stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case, of what I was trying to get straight with prosecution, and none of those questions were answered, as far as the legal terminology that we're using.
So what they're charging you with, or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly is being meant by the legal terms being used.
Conclusion to this whole mess. If you liked the video, hit the like button. If not, hit dislike. Don't forget to leave a comment below and subscribe with notifications on so you don't miss any future updates.